Hey everybody, welcome back to the channel. Today we've got some more shenanigans in the Ninth Circuit Court of Appeals. Not a CRPA lawsuit I wanted to talk about today. We're going to be talking about the open carry lawsuit of Baird v. Bonta. To help us walk through it, we've got volunteer CRPA President Chuck Michel. Chuck, thank you for being with us today.
Pleasure, fellas.
Absolutely. But before we get into that today, please, it is helping. Be sure to like, share, and subscribe to these videos. Hit that little notification bell. It's really helping with the algorithms to get this information out to as many people as possible. We want these videos to grow so that people can be more informed when they go to the ballot box in 2024. Okay, Chuck, so I wanted to get a run through of this. It's not a CRPA lawsuit, but it is in California. It's a challenge to open carry laws in California, and we've got some funky things happening with the Ninth Circuit. I know we just watched Duncan go through the en banc review for an appeal for a preliminary injunction. It seems like this lawsuit is kind of going through a similar process. But first, can you take us through the progression of this lawsuit as it stands today?
Okay, now I have not studied this as closely as I would like, but basically what's happened here is they file in the district court. This is the standard steps for all these cases. They file in the district court, the trial court, the first level federal court. They seek a preliminary injunction. The court has to evaluate whether or not to grant that preliminary injunction, and part of doing that is supposed to involve an evaluation of your likelihood of success on the merits. In the Baird case, they challenged California's open carry laws. Open carry is not entirely banned in California. In some counties, you can get an open carry license. I believe Baird's saying you shouldn't need a license. You should just be able to carry openly. But so the judge did not do in the district court, the trial court did not do that likelihood of success under Bruin. So the plaintiffs appealed to the Ninth Circuit to a 3-judge panel. That 3-judge panel looked at the analysis that was done in the preliminary injunction ruling, said you didn't do the analysis you're supposed to do on likelihood of success on the merits under Bruin. So they've started to send it back down, telling the judge to apply Bruin appropriately to figure out whether or not there's a likelihood of success on the merits. And remember, the analysis in Bruin, the methodology, which is what we're fighting about in all of these Ninth Circuit cases, is supposed to be, is it covered by the text of the Second Amendment? And carrying a firearm outside your home would be, it's bearing, keep is possess, bear is carry. And that's what they said in Bruin. This is just, the only difference is Bruin was licensed concealed carry, and this is licensed or unlicensed open carry. So you have to look and see whether the text of the Second Amendment covers it, which it does, and then look for historical analogs, laws from back around 1791 that would indicate that the founders would tolerate a ban on open carry today, because there was some similar ban back then. Well, there wasn't any similar open carry ban back then. There were some similar bans on concealed carry back then. So the question the courts are going to have to wrestle with is, if there's a historical analog that says you can ban concealed carry, is that limited to concealed carry? Or is that an analog for the manner of carry generally, whether it's concealed or open? Now, CRPA's position has always been, based on previous court rulings, that the legislature can regulate the manner of carry, but they can't ban. So they could say, you know, in an urban area, you can't carry open, but you have to give people a permit to carry concealed. In rural, and conceivably they could say, the legislature could say, okay, we want you to carry openly in urban areas too. In California, the approach they take is, if you're in a less populated county, you can get an open carry, get permission to carry openly. And if you're on your private property on a ranch or something, you don't need a permit at all. But the point is, at a minimum, the legislature cannot ban both open and concealed carry. They have to allow a manner of carry. So the district court judge did not do that analysis. And the Ninth Circuit 3-judge panel called them on it and said, you got to go back and figure out whether or not this open carry restriction in California has some historical analog. And then you have to analyze whether or not a historical analog on concealed carry might be used to ban or regulate open carry, provided you allow for concealed carry. So before it could be sent back down and considered, though, my understanding is that one of the judges on the Ninth Circuit requested that the case be taken up en banc, that is to the 11-judge panel again. Remember, this is going on in all of the cases. Duncan was taken back in front of an en banc panel. In Tedder, the Hawaii butterfly knife case, the state has asked for en banc review. That's being briefed right now. Wolford, which is the Hawaii sensitive places case, looks like that may be headed for en banc. Now, the lesson we can take from this is that the Ninth Circuit knows that the methodology that's being applied in all these cases is the key factor in whether or not a statute is going to be held constitutional or not. So the Ninth Circuit is looking at all these cases, not necessarily because of open versus concealed carry or butterfly knives or magazines that hold over 10 rounds. It's taking them all up en banc because it wants to challenge the Bruin, it wants to look at the way the Bruin case is applied. And the state has been arguing that we got it all wrong. It's not this simple two-step test, which Bruin clearly says it is. It's something much more complicated. And historical analogs don't have to be, they want to stretch the historical analog so that almost anything, if you ban a Bowie knife, that's the same as banning a semi-automatic rifle. So the lesson here from Baird and all these others is that the Ninth Circuit's going to make some kind of a ruling in one of these cases sooner or later about the methodology that's supposed to be applied in Bruin. And that could take a long time. We don't want to wait. And so we're looking for ways to short circuit that in the Duncan case, because that's the case that's in front of an en banc panel right now.
Well, okay, so I mean, I guess that is a form of bringing some logic to this. And I mean, as I've been watching the progression of this, you're kind of riding high when you get a federal district judge saying, no, I'm not going to grant you a preliminary injunction on this. And then you get a 3-judge panel from the Ninth Circuit sending it back to that federal district judge saying, hey, you got this wrong. You kind of can create that assumption that, like, hey, they didn't look at this correctly. Perhaps that injunction is appropriate. And then it just feels like it's snatched from you when you get this request for briefs to go to the Ninth Circuit. But what you're saying is this is kind of applying all the way across the board. The Ninth Circuit is specifically reviewing Second Amendment cases. I guess here's the other question, though. Are they looking to set their own precedent, or are they looking for the right precedent to be set? Because we have Bruin.
That's the question, okay? Now, we have several judges, for example, on the Duncan en banc, first time around en banc ruling, we had 4 judges that were in our favor. And clearly some of the judges on the Ninth Circuit understand what Bruin requires, but others may not and are resisting Bruin. So this is the ideological divide on the Ninth Circuit. And some of these judges are really battling with each other over how these cases should be handled and how the Bruin test should be applied. And thankfully, because of the Trump administration, that Ninth Circuit court is about 50-50 conservatives versus more progressive judges. And so this is going to be an issue that it's kind of, so for example, in Duncan, we had 7 judges against us, 4 judges for us. If we flip 2 votes, then we win. Will 2 liberal judges that voted against us when they only had the Heller case authority in front of them, will they flip their votes now, and because they are forced to recognize that Bruin requires them to declare more laws unconstitutional, like the magazine restriction ban? Or will they try and limit the textual test that, they're trying to say that magazines are not arms. So you have no right to keep and bear magazines because magazines are not arms. And they're trying to say that the time for looking for historical analogs runs through 1865 or even after, when the 14th Amendment was adopted, or even after. They want to look at more modern laws and say this justifies the other modern laws. That's not the way it's supposed to happen. But some courts across the country are getting twisted over how to apply Bruin. And so this is why I've said before, the methodology is the battle right now. It's not about semi-autos or magazines or butterfly knives or any other. In California, we've got the Billy Club case that's still pending in front of Judge Benitez. It's not so much about the individual arm that's being banned. It's the methodology that has to be applied under Bruin. And if it's applied faithfully, most of these arms bans are going to fall. They're going to be declared unconstitutional. But a lot of the judges, or at least probably, I don't know, but not probably 50-50, but some judges really care, and they don't want these cases, these laws to be struck down. And so they may be inclined to fight for to apply Bruin differently so that they can uphold the constitutionality of some of these laws that should be declared unconstitutional.
Well, maybe can we talk about, to the best of your ability, the makeup of the Ninth Circuit really quick? Because I guess my question is there potentially some silver lining in this process? When Duncan came up, the Ninth Circuit en banc panel made an argument, hey, this has already been in front of us technically twice. So, they were able to keep the 11 collective judges that already ruled against Duncan, on its way up to the Supreme Court the first time. But Baird hasn't been in front of a Ninth Circuit en banc panel. Does that mean that a new panel would have to be drawn from I think it's 29 judges?
A different 11 judge panel out of the 24 or 25 total judges on the Ninth Circuit. A different 11 judge panel would be drawn for Baird or Tedder or Wolford or the soon to come cases Miller from Judge Benitez or Rohde from Judge Benitez. Those will have to go through the 3-judge panel first, as Baird did, and then we'll get the rulings out of there. But the en banc panel on one of these other cases that are further along, like Duncan, may say that this is how you have to apply Bruin, and then those 3-judge panels would be bound by that en banc ruling that comes out of whichever case, and have to apply Bruin differently. Now, we're not going to let that stop there, and I don't think the Supreme Court is either. They're tired of courts twisting what they say, because they did it for 12 years after Heller. They completely misapplied Heller, and the Supreme Court had to straighten them out in the Bruin case and say, you've been applying Heller wrong. This is how you're supposed to apply it. But now some courts are applying Bruin wrong. So if it doesn't get resolved properly in front of some en banc panel in the Ninth Circuit, the Supreme Court will have to get involved. Okay,
well, I'm just sort of curious then, when it comes to, so you have catalysts that bring these lawsuits to these courts in general, but a couple things that you mentioned earlier about a constitutional argument for concealed carry versus open carry. I guess, and you guys can correct me or not correct me, but inform me of your own opinions in the chat or in the comment section. When I think of an American in 1791, new American, it's a guy who can walk out of his house and he can have a rifle over his shoulder, going from point A to point B. How has, we've seen concealed carry laws get challenged. I mean, that's what made it up to Bruin in the first place, right? The open carry challenges haven't been as prominent, even though they exist here in California. What is the difference that you kind of alluded to earlier, just as far as the court system choosing which one to regulate? How exactly does that work?
Well, you have to look at the analog and decide whether look at the historical laws that regulated concealed carry. Okay, that's a regulation on a manner of carry, generally. It's not a regulation that specifically bans open carry. It's a regulation that bans the manner of carry and says you can't carry concealed. Open carry was the norm for, decades. And so the question is a historical law that regulates the manner of carry by regulating and stopping concealed carry in some instances, is that a sufficient analog to say that you can ban open carry? Because you were regulating the manner of carry, i.e. concealed. Is that enough to say that you can regulate the manner of carry for open as well? And it shouldn't be. We support open carry, but our position has been historically, before Bruin, and it's probably going to wind up this way anyway, that the states can regulate the manner of carry, but they can't ban carry altogether. So in some areas they could say you can carry openly, but in others they'll say you can carry concealed, but you can't carry openly.
Yeah, that makes sense. I mean, you're basically saying you have to allow us to carry. If you want to choose whichever way we can carry, then I guess we can take that and work with it, but you can't ban it outright.
Well, it's only because, I mean, this is not a policy. This is, CRPA doesn't, our position is you have to allow at least one or the other. But historically, there were some regulations on concealed carry under certain circumstances, and that's the manner of carry. So the question is, can you make that jump? If you can regulate concealed carry, does that mean you can regulate the manner of carry? And that's what the court's going to have to decide. And that's what they sent the case back down, the Baird case back down to the district court to do. But now the en banc panel is trying to, one of the judges is trying to get an en banc panel to take it away.
Well, the briefs have been requested. We're going to definitely keep an eye on this. We're going to definitely keep an eye on which judges are selected to this panel. Any final thoughts on this, Chuck, as we move forward?
Just keep in mind, the methodology is key in all of these cases. We have to win methodology. We have to get the Bruin case applied the way the Supreme Court wanted it and instructed other courts to apply it. They can't get away. If they get away with this distortion, and if the Supreme Court doesn't set it straight, we'll be in trouble. But remember now, Rahimi is in front of the Supreme Court, and they will probably have to address methodology in that case. So we may get some clarification from that case on methodology before any of these en banc panels even rule. It remains to be seen. But we're hopeful, despite the fact that obviously Mr. Rahimi, who is being prosecuted for having a firearm when he was subject to a restraining order, which prohibits firearm possession, he's not the poster child for the Second Amendment. But nonetheless, if you apply Bruin faithfully, as the Fifth Circuit Court did in that case, you can't have this classification ban, this categorical ban on a class of people that doesn't pass the Bruin test, which is one of the reasons I think the states wanted to have Rahimi be the test case, the next test case in front of the Supreme Court, because they think that unsympathetic case, that unsympathetic plaintiff can be used to water down Bruin, weaken the methodology, and make it easier for them to win other cases where gun bans are being challenged under the Second Amendment.
Well, it would certainly fall in line with all of the emotional arguments that we see in politics today. Well, hey, nobody said the road wouldn't be bumpy, but we're sticking along for the ride regardless. Chuck, I really appreciate you taking the time today. Thanks for being with us.
Sure, my pleasure. Thanks, guys.
And if you like these videos and content like this, we're trying to keep you up to date with everything that's going on within Second Amendment litigation, legislation, and culture. Please drop a like, share, and subscribe to these videos. And again, hit that little notification bell so that you can get a notification when we drop these videos so you can stay up to date. Thanks, guys, and we'll see you on the next one.